again. We've started before 2. But you're all here, so that's good. Yes.
My lords, with the potential prize of plaudits in mind, I will take this as briefly as I possibly can.
We'll tell you. We'll tell you, by reference to the clock, just how pleased we are with you.
My lord, just concluding all the points I was making this morning, I say that the approach that we were advocating is reinforced by later authority of this court. I refer to the case of Maguire, and it's in tab 14 of the authorities bundle. Lord Justice Longmore, who was in the majority in Maguire, held, and if I could take the court to paragraph 91, at page 546.
Yeah.
It was, of course, a secondary exposure case, but Lord Justice Longmore held that paragraph 91, the court in Jeromeson had favoured the approach of Mr. Justice Buxton. And in my judgment, we are therefore bound to proceed on the basis that as between employer and employee, the employer will be in breach of duty if he fails to reduce his exposure to the greatest extent possible, and that meaning practicable. And my lord, just for your lordship's note, on the previous paragraph, he had also been considering the threshold argument and whether there was a breach in the absence of if those levels didn't exceed maximum permissible concentrations. And again, in this pre-1965 case, it's at the end of paragraph 90, which spills over into page 545. It's only when it's impracticable to reduce the dust that permissible concentrations can have any relevance in relation to employees. So, my lord, that's all I wanted to say about Maguire, to make those references.
Yes, I mean, although, I mean, despite so addressing them, they so directing themselves, they allowed the defendant's appeal.
Well, it was a secondary exposure case.
Well, that was only because of the secondary exposure point.
That's the inference that I draw from what Justice Longmore says.
Is that consistent with the passage we were taken to from Lord Justice Judge?
That was paragraph 58. Well, I say it didn't arise for consideration. Certainly the ratio depends upon this being in a secondary exposure case. We have, for what it is worth, we have Lord Justice Longmore's view of the situation where the duty nexus of the employer and the employee. My lords, can I move on to just very briefly deal with Abraham? I won't say very much about this.
Yeah.
Simply to say that Abraham is a different case on the facts, I would simply draw your lordship's attention to some of the findings of facts in Abraham. It's at tab 18 of the authorities bundle. Paragraph 39 at page 703. I'm not sure I need to take you to the particular passages, but the finding was that the soldering of which used the scorch pads only took a few minutes.
Just read the paragraph.
I beg your pardon, my lord.
Wouldn't that be quicker?
Yes, my lord.
Yes.
And my lord, in relation, and paragraph 42, if I may, page 704, the latter half of that paragraph, where I find at the occasions, essentially it stated it was infrequent in the open air. And my lord, just finally on Abraham, it's worth saying that the employer in this case was of a very different nature. The first defendant was a small firm of builders, that's a paragraph 5, and the second defendant was a small plumbing firm. And Mrs. Justice Swift held at paragraph 86. Things might have been different if the employer had some special knowledge. That's at page 700 and 750.
But in that respect, they're exactly the same. Because it's not suggested that the employers, in this case, these appeals, had special knowledge.
Well, my lord, I'd say this is in the White case, the employer is the state effectively. So it is taken. Well, I would respectfully submit it's taken to know all of the information that's been put before the court.
Okay, yeah.
Is that right, by the way? Why should the state be taken to know? Why should someone working in a hospital be taken to know everything that the factory inspector knows, if that's what you're saying? Simply because they're all emanations of the Crown.
Well, my lord, it's a point I suppose I'd rather assumed rather than have the authority to support it. But my understanding of the emanation of the state
has a sort of instinctive.
Yeah.
But it's not really the real world, is it?
Well, it's a large hospital which is subject to and given edicts from various.
But it is not suggested. It is not suggested in this case. I was just picking up on your reference to Ms. Justice Swift saying special knowledge.
Yes.
It's not suggested that either of the employers in this case had particular knowledge, so that they, for example, knew better than other people, or were aware in advance of the watershed that minimal exposure could.
No, I don't take it too far. I simply make the comparison. Say the employer's identity is relevant. And in Abraham, you have small plumbing firms, and here we have.
It doesn't matter that much. We're not bound by Abraham anyway, so.
I don't know. I've simply. I just come briefly to some of the additional arguments, and I'll take them very quickly. One is that the appellant.
Is the respondent's argument?
Yes, I beg your pardon, my lord. The appellant is seeking to circumvent Baker and Quantum. And it said that we are seeking to introduce an objective definition of safety. My lords, for the sake of clarity and the avoidance of doubt, we are not attempting to do so. We say wholly in accordance with Baker. The court must consider in this context what would have been safe by the standards of the day, and the court already knows what we say about that. My lords. Secondly, is that a related argument is that the appellant takes what's been described as an absolutist approach or seeks some form of strict liability. Well, my lord, we disavow any suggestion that strict liability would arise in this case or this situation. It is still necessary for the court to prove, for the claimant to prove a breach of duty, and that is where the concept of reasonable practicability comes in. And if one's considering questions of reasonable practicability, the obvious factors would include the following. I have 5 in total. One was the exposure a result of working directly with asbestos products and asbestos materials, as in this case, or was it some form of bystander exposure, as in William? Secondly, did the employee work with asbestos on a daily or regular basis, or could weeks go by without any exposure? Thirdly, was the exposure an integral or usual part of the job, or was it a mere possibility, as in a case such as Asmussen? Fourthly, a point I've already made was the identity of the employer, what they knew and their resources. And fifthly, what was the potential cost of preventative measures, and could they have been introduced without excessive?
I don't understand this submission. I'm sorry, my fault, I'm sure. You maintained this morning that your submission is that anybody who exposes, certainly in an employment context, anybody who exposed someone to any asbestos it was not de minimis and therefore couldn't be caused to, was under a duty to take steps. Well, did he work with asbestos on a daily basis? That's got nothing to do with steps, either the existence of the duty or breach, really, is it?
No, my lord, I expressed it badly. I said the duty arises, and then what is reasonably practicable depends upon the circumstances of the case. So these are focused more towards what would be a breach and what would be expected of the employer. And what reduces to the reasonable, what is required to reduce to a reasonably practicable level is determined by factors such as these. I'm not sure that satisfies you, but that's the submission.
Well, I was just being good and not piling in again.
Very well. Well, I'll take that chance and move on. My lord, the appellant contends that the respondent contends the appellant hasn't dealt with the regulatory, what is called the regulatory response test. Our submission in respect to that is that it's not a recognised test and has little use as an analytical tool. My lord, the premise of the appeal is simply that the judge was wrong to find that the employer owed no duty. And my lord, perhaps it's related to the previous point which you didn't like, but the regulatory response might conceivably have a bearing on the extent of the measures that would be required in satisfaction of that duty. But we say it logically can't have a bearing on the prior question of whether there was a duty.
And just to be clear, I mean, the judge said that he considered that the response, had there been an inquiry, would, on the balance of probabilities, have been that there was no need to do anything.
My lord, yes, he did say that.
Now, do you say that doesn't matter?
My lord, we said it's a different question, really. We say by operation of law, by operation of all the things my lord, I've submitted this morning, I won't repeat them. We say that that duty arose really as a matter of course because of the way in which we submit the legal framework determines the duty.
I suppose that's right. Is there a breach if, supposing they recognised that something needed to be done and they'd taken advice, then they'd have been told they didn't do anything?
Well, my lord, we say on the facts of this case, because the step was so easy, it was to use a different type of mat. That is how the claimant would get home on breach, because so little was required. And that's, I suppose, in a rather perhaps a confusing way, why I was trying to draw in what is reasonably practicable and what isn't. My lords, can I come to a final point, which is it's actually an issue raised by my lord, the vice president yesterday. Is would this be is this an attempt to overturn the orthodoxy of the watershed? Our response to that is really first the Newhouse and Thompson paper in 1965 was clearly very important, an important development, but it wasn't the only thing going on in the 60s. It was technology had also become available to measure levels of dust and set empirical standards. The courts in post-1965 cases have naturally focused on the mesothelioma risk because it's the one which requires a lesser amount of exposure. And in some cases, vanishingly small quantities of exposure. I was may know the facts, for example, of Wilmore in the Sankiewicz appeal with the teacher who had a couple of.
Speak up a little.
I beg your pardon. Some asbestos panels that may or may not have been disturbed. So it is a different quality, or you say, a different category of exposure that can become relevant. And this position that we take, we respectfully submit, doesn't collapse the pre and post 1965 distinction, because post watershed, as we call it, levels of exposure that are essentially almost undetectable could become relevant. a further difference and a further effect of the post-1965, because of Newhouse and Thompson, because of the Sunday Times article that followed it, is to put the spotlight on domestic and domestic and secondary exposure. And we say the effect of that was to expand the duty to take all reasonable precautions and to take it beyond the employer relationship. So, my lord, the differences remain, or a difference remains. And ultimately, we say if the authorities had took the judge to that destination, even if he didn't perceive it to be orthodox, we still say it's where he should have gone.
I'm being very slow this afternoon, but you just said, as I took it down, post-watershed, very low exposures could become relevant.
I think I wrote down almost undetectable, didn't I?
Well, my lord, post 1965.
Post 1965, but 1965, post Thompson. But your whole thesis or submission is that very low exposures, any exposures in an employment context, were relevant before the watershed.
Well, my lord, yes, in the circumstances where they are more than de minimis, yes.
So there's no watershed at all, except for the fact that before then nobody realised that low exposure could cause injury, and after the watershed they did realise.
Well, Lord, we say it extends it to non-employees, essentially.
Well, that was a different point.
Right.
Like my lord, I noticed you started by saying that it made a difference about levels. Like my lord, I thought that was contrary to your primary submission.
That is my primary submission, yes. But my lord, an example would be Williams, where this court accepted that there could be an exposure level that didn't give rise to a breach of duty. My lord, I won't pursue the point if it doesn't find favour, but my lord, our submission is that essentially that this doesn't collapse the distinction, at least for the reason that it extends the duty to non-employees. My lords,
You've done well. You've done well. You get plaudits.
I've done it as fast as I could.
My lords don't attempt to deprive you of them by asking you some further difficult questions.
Even if it confused the court, I have at least kept to the time.
Thank you very much. Yes, Mr. Flower, you've got plenty of time now.
Yes. Lords, with your leave, what I propose to do is offer, if I may, two alternative routes, we say, to the inevitable dismissal of this appeal. There's the short route and the long route. The short route essentially says that the central questions on this appeal are matters of fact, and that the judge's findings of fact are not challenged and are ultimately dispositive of the appeal. And those findings of fact are the finding that the dose was not more than minimal, and his findings of fact on what the reasonable employer in the 1950s ought to have known or could have known from the available documentation, which is sometimes called historical foreseeability, and that's a rather inelegant phrase. Secondly, we say that there are findings of fact on what advice the respondent, the appellant, would have received had he sought advice on the safety of having mats on a lab table. And as has been debated between the bench and Mr. Steinberg, that was a finding of fact that the hospital would have been told that their system of work was unobjectionable. And to pursue the point made by Lord Justice Stuart-Smith, given that that finding is not challenged, it's difficult to see how my friend really can get out from that particular hole in which he's dug himself, we say, because it is a finding of fact and it is dispositive, we say. So those are, in very brief terms, the short route. The longer route is to say that if indeed it is a matter of law, mixed law and fact, then still the judge's decision was unimpeachable. And we can best illustrate that by looking at the decision of Mrs. Justice Swift in Abraham, which my friends have sought to distinguish, but actually is very similar, and certainly some of her comments we would adopt. But we would suggest you could go a little bit further than she went in Abraham. So that's the longer route. On the short route, the Lord, and questions of fact, the judge referred to Bussey. I'm sure your Lordship, the Vice President, will be familiar with this, but the role of fact is set out in paragraph 38 of the judgment, which will be found in tab 28, page 1058. Where Lord Justice Jackson said, there are, of course, many first instance decisions on foreseeability of the risk of mesothelioma at different dates. Clearly, this would be mesothelioma, not asbestos. Counsel have taken us through several of them. Each one turns on the circumstances of that case and the expert evidence which was called. I bear those decisions in mind, but do not embark on the recitation of those authorities. And then if one goes to paragraph 46, he goes on, as previously noted in paragraph 61, Lord Justice Aitkins held that TDM 13 was the best guide to what were acceptable and unacceptable levels of exposure in 74. He was not there formulating a principle of law, he was setting out a mixed finding of fact and law. That finding was based upon the expert evidence adduced in the case before him.
So where was the earlier reference you gave us?
Sorry, paragraph 38.
38.
The later one,
46.
46, thank you.
And then, of course, in your Lordship, the Vice President will remember this. What you did in that case was that you remitted it back to the trial judge, because it was ultimately a matter of fact. If Mr. Steinberg is correct, what you would have done is to have presumably entered judgment for the claimant in those circumstances. But because it is a matter of fact, it went back to was remitted back, and ultimately the case was in fact compromised. The same approach to questions of fact in these cases was taken in Watt and Lend-Lease Construction in Scotland in the Outer House. I turned up, if your Lordships would like to look at it, that's in the Appeal Bundle tab 46.
Authorities bundle.
Sorry, Authorities Bundle, I beg your Lordship. Tab 46 at 1349. Essentially, it makes the same point. The case was appealed to the Inner House on the basis that the trial judge, Lord Ewist, had essentially outsourced findings of fact to Mrs. Justice Swift in Abraham, and the Inner House wasn't having any of that, and the appeal was dismissed. But again, it makes the same point about these matters being fundamentally questions of fact.
So, did you have a page? For
sorry, my Lord. The Outer House judgment is page 1349. I can take it, perhaps it's easier if I take yours. It's in tab 46, right at the back. It's in paragraph 18, top left-hand corner on page 1346. Where Lord Ewist says, in moving me to find the defenders liable to the pursuers for Watt's death in the agreed sums, counsel for the pursuers made reference to the following cases, and then he sets out a number of cases which are all familiar to us all. And he goes on, these cases all dealt with the question of foreseeability of injury.
So where are you reading from?
Sorry, my Lord.
I thought you said 1346.
1349.
Oh, right.
And it's paragraph 18.
No problem. Okay, yeah.
And he cites those cases. These cases all deal with the question of foreseeability of injury and turned on their own facts. The foreseeable risk need not be that of mesothelioma. And that was proved by the Inner House. I don't think, my Lords, we need to turn that up because it really went on this issue about whether he'd outsourced to Mrs. Justice Swift. I say that's a correct statement of the law.
We've got the decision of the Inner House there, have we?
We have got. Yeah.
Is this sort of paragraph 13? This is page 1288, isn't it?
Lord, that is correct. It's the, well, it's in fact also paragraph 12 at the top of page 7, that judgment on page 1288, where they said he didn't adopt the factual determinations that Abraham was right to endorse an approach that required him to assess the evidence rating degree of exposure. Well, then, looking briefly at the facts, in this case, they have obviously been canvassed in argument. If we look at the judgment of the learned judge at page 103 of the core appeal bundle, I'm afraid to go through these, so I shan't read them out. So this is page 103, it's paragraph 1950. And your lordships will see in the the second sub-paragraph of paragraph 1950, the finding of a concentration on a time-weighted average of 0.02 to 0.055 mils. And just to orientate ourselves with that, that is a 100th, if you take 0.2, of the level in the TDM 13 1970 time-weighted permissible average. And it's 1,000th of the level set out in the toxic substances.
In the what?
In the toxic substances documentation, line of documents from 1960. And it's a tiny volume of exposure, which is why the learned judge said at the bottom of page 9, at the very least, I am persuaded by
Bottom of page 9.
Sorry, my lord. That's 9 of the judgment. Page 103.
Right.
Looking at the internal.
At the very least, that's the last 5 words.
Yes, at the very least, I am persuaded by Mr. Houston's evidence that the likely level of exposure during this period was modest and frequent, and in overall terms, not more than minimal. So we say that not more than minimal is a sort of catchphrase that one can carry through to the issues of foreseeability. On the question of foreseeability and the test, I don't take it from the friend's submissions that he challenges paragraph 43, which is where the learned judge set out his approach to the question, and he would have been a brave man too, since those are the tests set out in Bussey by my lord the Vice President, namely that should in the first period of employment, should the employer have been aware that exposure gave rise to a significant risk of asbestos injury, and if he did SEFT and take proper precautions, or at least take advice on the level of exposure. The word significant was used by my lord the Vice President in Bussey. I don't take issue with that in terms of the way in which it's put, i.e. any real risk. There's another formulation by Lord Dyson and Baker and Quantum at page 875, which is more than minimal, but I think that's a distinction without a difference, and I don't seek to urge the court any other way. So I've taken it from a friend's submissions that he's happy with the test that the judge posed himself. And then clearly he answered it in terms of the level of dose and questions of foreseeability or historical foreseeability, or what the average employer should have known in the 1950s in 3 paragraphs. The first paragraph is paragraph 45 on page 113, where the judge says, on this issue, Mr. Houston's evidence is helpful. He explains that throughout the 50s and the early 60s, the prevailing view was that occasional and relatively low-level exposure to asbestos, even in industrial processes, and the application of asbestos lagging was not thought to be hazardous and would not have warranted precautions such as segregation of the workplace or the use of respiratory protection.
What do we do if we were tempted to go with Mr. Steinberg's analysis? What do we do if we think that that is actually different from what he is asserting?
Right.
This is a finding of fact,
Yeah.
as you submit,
Yeah.
that in the 1950s it was not thought to be hazardous. Obviously, it depends on volumes and intensities and so on.
His case has to be, well, that may be a finding of fact, but legal foreseeability is such that we have this absolute view that regardless of what the average employer knew, in fact, he should have been taking precautions. I will struggle to see how you make good that submission, but that must follow from his case, as opposed to what we might term the more pragmatic case that Mr. Halton's running. But I do say that it's determinative in this case, given it's a finding of fact. And the other two findings are in paragraph 66. Which is he says, having regard to the evidence of Mr. Hewson, so he takes that in, and the absence of any expert evidence from the claimants to the contrary. And obviously that was quite an important point in this case. The claimants did have their own expert evidence, but I decided not to call any expert evidence. He says, my answers to the questions derived from Jeromeson and Bussier as follows. Should Sefton Hospital, in either period of employment, have been aware that exposure to asbestos dust, which his work involved, gave rise to significant risk of asbestos-related injury? No. In respect of both the first and second period, I found that exposure to dust was not more than minimal, certainly not a level that triggered a duty on the defendant to take precautions or seek advice. And then the third reference I take your lordship to is really a further recital, the top of page 120 in paragraph 68, where the learned judge says, for the reasons I've given, I've concluded that the defendant did not know and cannot reasonably have been expected to have known during the period 1949 to 1960 that asbestos dust in minimal quantities in which the claimant was likely to be exposed was a risk against which they should have guarded by taking reasonable steps or taking any others. So Lord, I say those three issues are factually determinative of the evidence before the judge in the case. If, though, my lords, you are not with me on that, and the threshold test to act is met, then we have the issue of what the employer does and what happens if he inquires of regulatory authorities or experts. The learned judge dealt with that in three separate paragraphs. First one was paragraph 43. 2, when he asked the question about is a duty to seek advice triggered, and he answers that in paragraph 44, which I say is both a commentary and a correct observation on the law in this area. So he says, in my view, in paragraph 44, in a case where no positive case is advanced by the defendant that any steps were taken at all in respect of the risk of asbestos dust, there is a necessary relationship between stage 1 and 2. It would seem to me odd to find the defendant in breach of duty if, had appropriate advice been sought, the hospital would reasonably have been advised that the risk of asbestos-related injury was sufficiently low and negligible as to not be worth troubling about. Equally, it would seem odd not to find a breach of duty if, had appropriate advice been sought, the hospital would have been reasonably advised to take at least some precautions to reduce the risk of asbestos-related injury. I say that must be right. In a sense, you could answer the first question by reference to the second question of what would happen if you took advice. Because if that is a question of fact, which we say it is, and if that advice was having lab mats made of asbestos on the lab benches was perfectly safe as viewed from the 1950s, that really is almost an answer to the whole case. Finally, Lords, paragraph 59 is where you make the finding that had the hospital gone to regulatory or expert sources, they would have received the thumbs up as to what they were doing. That extract, which I won't read out unless your lordships want me to, is 6 lines down from paragraph 59 that starts, in the light of this, Mr. Hewson reached what I consider to be a reasonable conclusion that the levels of exposure implied by the deceased evidence would have been considered trivial by the standards of the day. It says it follows that and then it goes on to deal with the way Mr. Justice Swift dealt with it in Abraham and Arison, and says, had they been sought third-party advice on it, then that's the answer they would have received, which was that the system works.
But it's slightly more nuanced than that, because he allows for the possibility that someone might have said reduce, reduce, reduce.
But I think
then on the balance of probabilities, the more likely outcome is.
so. That's his finding on the balance of probability. And the duty to inquire test is one that's mentioned in almost all the main authorities. I'm not going to take your lordships to them all, but just for your lordship's note, it's mentioned in Jeromson at paragraph 52. That test is recited in Asmussen at paragraph 54.
What was the para in Jeromson?
52.
Yeah.
Recited in Asmussen at 54. It's obviously in Abraham at paragraph 86. And it's in Williams at paragraph 35.
Nevertheless, ultimately, it's a sort of thought experiment to help you answer the actual question, which is simply what ought you to have known. Because there may be cases where it's not, where for particular reasons it's not actually the most helpful way of addressing that question. I think one of the authorities mentions that, I forget which one. I think it's Jeromson actually, that it doesn't really matter what would have happened if you'd inquired. Am I imagining this?
But I'm not.
No, well,
familiar.
maybe I'm misremembering it, but well, forget that frill on the point I was making. The basic point is that it's not the test as such. It is merely a consequence of the test or a thought experiment that will help you decide what the answer would be. Is that right?
Well,
Because the advice you get is likely to reflect the what a reasonable employer would have known at the time.
Well, it may be slightly different because what the reasonable employer may have known may have been different to what regulatory authorities may have known. So there may be that distinction. So if you've got to go to a higher level and say what would the regulatory authorities have known, then a fortiori, the reasonable employer should be able to be happy with that response and satisfy that test.
It's reflective of the test in negligence as it's applied to other areas. For example, in the field of medical negligence, you test the position, or you can test the position by saying, would a reasonable body of people have adopted a particular way? You may still knock it over by saying it's completely irrational, but it's a start, because if a reasonable body of people can not irrationally say that something is reasonable, then the court is going to be either slow to find or will not find. I'm thinking aloud at the moment, but they will not find that it's negligent not to have done.
But it's not quite analogous, is it? Because by definition, a doctor is an expert in the field in question. By asking the question my lord has identified, you're really asking what would other people like him or her have decided. Whereas here, not all employers have access to a source of expert advice, or sorry, do not themselves know all this material. And that's why there may be circumstances in which the question is, did they know enough to at least ask, and then what would they have been told?
My lord's point about a Bolam test is a valid one, which I've thought about as to whether it could apply in asbestos litigation, where some people are saying it's dangerous and other people are saying, no, you can go ahead and do it. And I do think it has merit, but we didn't seek to pursue that on this appeal.
And my lord is right about the difference, but I may still cling on to the analogy on the basis that in one you're looking for the reasonable doctor, making an assumption of a certain level of expertise as a doctor. And here we're looking at a reasonable employer making certain assumptions about so for example, the more modest employer within limits is not going to get out on the basis that he's just slightly less knowledgeable than the average. He's going to be judged as the average.
But if there's a body of material that suggests that actually you're totally safe and there's no risk of asbestosis, and there's another body that says, well, maybe you need a danger, I would submit that on a Bolam basis, you could go for the former. And that's not the way we put the case, because we said subjectively there's no risk of asbestosis, but I do say that that's a possibility.
What happens, suppose you're an employer and you believe there is a risk, but if you had followed that up by taking advice, you'd been told, no, it's fine. Well, what's the position then?
Well, Lord, it's difficult to imagine that set of facts. I need to reflect on that. I would have thought that depends if that knowledge is accurate or not. If you're saying it's absolutely true.
I'm assuming that when you take your advice from a very reliable source, you're told it's all fine. You've had a fear that you needn't have had. I'm worrying about how far this is about duty and how far it's about breach.
I think you're right.
Yeah, but I suppose the issue would be that if you do believe you're at risk, then you will be taking steps anyway. So you're never going to get to that stage of
But
seeking.
the point is, if you harbour the belief, it may not be sufficient to give rise to a duty. The circumstances in which it may give rise to duty is if you have special knowledge, in which case it does. So the employer, as I think as you're suggesting, is the employer who thinks there may be a problem here, but that's not that's not a duty creating obligation. He may take steps, but if he didn't, he wouldn't be held in breach of duty.
Well, I think that's a good way of putting it.
I think.
I would adopt that approach to it. What I say is that on any basis, the judge made those findings, and it's difficult to detect from the learned friend what his response to it is, apart from to try and go right around the outside of the argument. I don't see as a finding of fact how he's actually trying to challenge it, and he's not challenging it in his grounds of appeal. And again, we say that is determinative of the facts of this particular case. Well, then so that's just the straight factual short route. There's then the longer route, which has obviously been canvassed for a lot of the last 2 days. Essentially, we say that if you step back, look at the literature, look at the law, you end up back in the same position as the learned judge was in. And that Abraham is quite a useful guide for that. I appreciate, my Lord, it's a decision of first instance. But I do say it's got more than that simple status. So it has not been the subject of discussion in the Court of Appeal yet, because it came after Jeromeson and Maguire, obviously. And it was a pre-65 case, and Bussey and Williams are both post-65 cases. So it's never in fact been, that I can see, debated in the Court of Appeal. However, Abraham was cited with apparent approval by Mr. Justice Simon and Asmussen. And that's paragraphs 23, 54 and 68. And Asmussen was approved by the Court of Appeal in Williams. You see why? I appreciate this is an unusual way of doing it, but Asmussen was cited with approval in Williams in the Court of Appeal at 36, 37 and 58, those paragraphs. Also, as we've seen, Abraham was used as the basis for the judgment of the Outer House in Watt, that Scottish case we looked at, and that approach was not in any way disapproved of by the Inner House. So it has got a measure of credibility on those grounds. The final grounds, that to echo what Mr. Rawlinson says, is that it was a decision of Mrs. Justice Swift. I'm not aware Mrs. Justice Swift was ever successfully appealed in an industrial disease case. She'd never appealed.
Well, I think you can take it. We all know Mrs. Justice
Yes.
Swift's status, but
Yeah.
still, it doesn't. None of that makes it formally binding.
No. I don't suggest it does. I do pray and aid the fact that it is.
It's highly persuasive.
Yes.
So we'll just deal very briefly with Abraham, which is in tab 18, first bundle of authorities. My friend's taking you to the essential, second bundle of authorities. the three areas of work, well, first of all, the period of exposure was 56 to 62, so it's all pre-65. The three areas of work were asbestos scorch pad, caulking, and cutting asbestos flues. The flues appears not to have been credited by the judge, and we're really only looking at scorch pads and caulking. The doses, and again, I'm wary of, my lord, the Vice President's injunction not to start comparing first instance decisions on dose, but I did want to make one point, which is in paragraph 31 on page 702, where Dr. Jones, who was the expert for the defendant, did a dose calculation. And in the last three lines of paragraph 31, he suggested that the average shift average exposure would be in the range of 0.005 to 0.05 fibers per milliliter on the days when the work was undertaken. Now, obviously, in this case, the dose was 0.02 to 0.05, so actually it's very comparable in terms of simple dose. In paragraph 32, you'll see that there was no dose calculated for the caulking because there was no research on that level of exposure at all. And where the judge came to her conclusions might be found in paragraph 46. And again, aware of the semantics between quantitative adjectives. She says in 46 and then into 47, she says, I'm satisfied on the evidence that the asbestos exposure the claimant had with the first defendants was very light and occurred intermittently. Although his exposure with the second defendant was somewhat more frequent, it was nevertheless still modest. I take modest as being more than very light and infrequent. And then she goes on in 47, mesothelioma disease, which is almost invariably, if not always, caused by exposure to asbestos dust and fibers. Although the claimant's asbestos exposure was modest, the overwhelming likelihood is that it caused mesothelioma, I so find. And our, as it were, our exposure is not more than minimal. And I do say actually that I entirely understand why the skepticism expressed on what qualitative adjective or these adverbs were used in such circumstances. But I do say that the exposure in Abraham appears to have been more. Then very briefly to just deal with the rest of her findings, the tested negligence she posited at 51, what we say was the correct one, and I know her friends haven't challenged that. And again, she incorporated the seeking advice test as part of the precautions. And then her views, just to cut across this, because obviously I'm conscious generally of time, was that Jeromson and Owen could be distinguished because they were heavy exposure cases, and we say that's right. And she also said, well, you may not be bound by the 1960s toxic substance limits, but the exposure is so far less than that the employer could take some sort of reassurance. And again, as an approach, we say that's absolutely right, even though when one looks at some more literature, we go a little bit further than that. So, can I then go to the literature? Because I wanted to deal with some points made by Mr. Rawlinson yesterday. First of all, Merriweather and Price, which is in the Cuthbert engineering volume 2.
Which bundle?
Bundle, it's Cuthbert bundle 2.
Supplementary bundle 2.
Yes, supplementary.
Supplementary bundle, sorry, supplementary bundle, yeah. The point that your lordships were not really taken to, I'll assume that I won't go over the ground that Mr. Rawlinson has covered, but on page 55, Dr. Merriweather says in the third paragraph down under results of the inquiry, he says, in common with other essential organs of the body, the lungs have a large reserve of tissue for use in emergencies and to permit of a diminution in functional capacity due to advancing age or disease. For this reason, and because fibrosis of the lungs is essentially a local disease, it is only when the fibrosis progresses to the extent of obliterating this reserve that undue shortness of breath on any extra effort draws the worker's attention to the fact that his health is not what it should be. So this reserve is important because it does underline why Dr. Meriwether takes the approach that we'll see looking at this in the tubercle article. And if we then go over to page 58, there's a passage at the top of page 58. Well, perhaps just before we get to that, Lord, the table has already been canvassed, and your Lordship was, my Lord Stuart-Smith was involved in a discussion with Mr. Rawlinson about the 0 incidents between 0 to 4 years. And then he took you to the tubercle article, which I'll come to. But it is still significant for reasons I'll explain. If we go to the next page, on page 57, Dr. Meriwether looks at the epidemiology and says in the last paragraph there, the outstanding point brought out in this way is the relatively very low incidence of rate of fibrosis in group 3, which are termed spinners for convenience. As compared with each of the other groups, there's some indication also that amongst spinners, the disease has taken longer to develop. And then if we go over to the next page, the top of the page is somewhat obscured in my copy, so I've written in what the words say.
Thank you.
It says, my Lord, in fact, the history and medical and radiological features of the cases of fibrosis, together with the results of comparison of the dust counts, all contribute to a degree.
Together with the result of, yeah.
With the results of comparison of the dust counts,
yeah,
all contribute to some degree to the view that with comparatively low concentrations of dust in the neighbourhood of a process, the resulting cases of fibrosis amongst the workers in that process are longer in developing and remain longer in a milder stage. It follows, therefore, that in such cases, the rate of accumulation of dust in the lung has not greatly exceeded the rate of elimination. And a further point of great practical importance emerges, namely, that in order to prevent the full development of the disease amongst asbestos workers within the space of an average working lifetime, it is necessary to reduce the concentration of dust in the air of the workrooms to a figure below that pertaining to spinning at the time over which these cases were exposed.
So just to help me, remind me, what is the rate of elimination reference to?
That's of the dust from the lungs, the natural rate of elimination that occurs, which means that low levels of exposure don't cause asbestosis. But clearly, the higher it is, the more likely it is to overcome the reserve in the body's defences. The question of spinners, my lords, is the key to understanding, we say, the later article of Dr. Meriwether. So spinning itself is a process which is set out on page 70. And you'll see 70 in the engineering section of this bundle. And it's the last penultimate paragraph where the author says spinning and doubling is in italics, and then if you miss out the first paragraph, which involves certain terminology, we don't need to labour. It then goes on, spinning, more particularly ring spinning, gives rise to dust continuously produced by the ballooning out of the fibre owing to the rapid rotation of the spindles, which may run at speeds of 1700 revolutions per minute, and intimately when the yarn breaks. And then he goes on to describe what's involved in it, but it clearly is generating substantial amounts of asbestos.
So this is spinning of asbestos, is it?
Yes, in the textile industry.
Yes, that's it.
So when he talks about the spinners, that's the process that he's referring to. And if we go back then to page 58, you can see in table 5 the relative dustiness of the various processes. And spinning is the index risk taken there at 1 in table 5 at the bottom of page 58. And then if we look at two other extracts on the following page, 59, in the penultimate paragraph, which starts on page 59, Simpson reports. If we go 6 lines into that, I see that the doctor says,
Sorry, which page?
sorry, 59.
Thank you.
It's about 7 lines. It's the penultimate, three paragraphs up from the bottom.
Yeah.
Where it's 6, 7 lines into that paragraph. It says, it seems probable, therefore, that although further research is necessary, that not only is a certain minimal quantity of the dust required for the production of a generalized fibrosis, but that inhalation of the dust in higher concentration results in the production of a more marked degree of fibrosis in a shorter time than when the concentration is low. And then finally, if one jumps to the final paragraph there, he goes on to say, despite this, some confirmation of the hypothesis that the length of exposure to asbestos dust is necessary to produce fibrosis varies inversely with the concentration of the dust in the air within certain low and high limits, so may be obtained. So again, he is looking, we would say, at certain limits. And then finally, 2 final references, page 61, the 3rd paragraph in there. It says, to sum up, therefore, it appears probable that concentrations of dust and length of exposure as factors in the production of fibrosis are interdependent within certain limits. Whilst it seems necessary for the production of generalized fibrosis of the lungs that a definite minimal quantity of dust must be inhaled, the lower the concentration of dust in the air breathed, the longer the lapse of time before the fibrosis is fully developed. And within a certain limit, the higher the concentration of dust, the sooner the fibrosis becomes fully developed. And finally, at 77, the penultimate paragraph on that page, which is the section is entitled Summary and Recommendations. And it says, the appropriate methods for suppression of dust may only be fully determined when the harmful effects of comparatively low concentrations of asbestos dust are duly appreciated. Very dusty processes will not fail to be recognized, but in processes such as spinning and weaving, in which in other textile trades special methods of dust control are not required, due precautions are also necessary. Asbestos manufacturers are clearly confronted with the necessity of attaining conditions in the industry which will ensure much less dust in the atmosphere and can safely be tolerated in many comparable trades not using asbestos. Now, what the tubercle article does is it picks up on that reference, which I took your lordships to at page 858, about the spinners and what was known after further research as to the effect of dust on spinning. And that is in the archive bundle, page 1960.
Are you going to come back to Maryland?
I wasn't going to Maryland. But what my friend used it for.
So what page do you say?
Sorry, Lord, in the archive bundle or the reference bundle, it's page 1960. The PDF is 1219.
Yeah, thank you.
Essentially, what I will say by way of kind of overview is that Mr. Olson took this document, to demonstrate that under 5 years there could be cases of fibrosis, and that is correct. If you force enough asbestos at any particular individual, you'll get a fibrotic physiological response in under 5 years if you do sufficiently. But what this document does do is it looks at the data on spinners and establishes what was termed a dust datum level. The other point to make is that it appears, certainly looking at the 4th paragraph on page 1960, that the cohort he was using was still the 1928 and 1929 cohort. There had been some further research done on some of the members of that cohort. So Mr. Rawlinson took you to page 1961 on the left-hand page there and read out the first two paragraphs which deal with this suggestion that up to 5 years isn't an absolute get-out-of-jail card for those who may develop asbestosis. But then if one goes down to 3 paragraphs from the bottom and go into that paragraph 5 or 6 lines down, you'll see there's a passage that starts, similar considerations also show that below a certain concentration, which will be referred to later, development of a disabling degree of asbestosis will not occur within the space of an average working lifetime. It follows, therefore, and this is important from the practical point of view of prevention, that a certain minimum fibrosis-producing amount, as it were, of asbestos dust must be trapped in the lungs in order to produce a potentially disabling or serious amount of fibrosis, and also that a certain maturation period must elapse before that amount of fibrosis is developed. Then if one goes on to page 1963, right to the bottom of the left-hand page, the author, Dr. Merriweather, goes on, this is just under table 4. If only the slightest exposure of the dust results ultimately in death, then the scope of the necessary preventative measures is summed up in one word: prohibition. But practically speaking, it's impossible to prevent such exposure. So that's the proposition. And then he goes on. Fortunately, however, there is evidence that an appreciable amount of dust must be incarcerated in the lungs to produce a serious degree of fibrosis. Inquiry into the relative dustiness of various processes and the relative incidence rates of asbestosis amongst workers in those processes provides data which go far to confirm this point of view. And then we go to the bottom of that page, and the last 2 paragraphs in it, and it says, for these reasons, and from examination of the varying conditions of exposure to dust amongst spinners in individual factories, it appeared reasonable to infer that the exposure of workers in this group to dust as a whole was not greatly in excess of the maximum safe limit. So again, he's talking about a maximum safe limit. One of the conclusions, therefore, of the original investigation was that in order to prevent the full development of the disease amongst asbestos workers within the space of an average working lifetime, it is necessary to reduce the concentration of dust in the air of the workrooms to a figure below that pertaining to spinning at a time at which these cases were exposed. This reduction was later accepted in the light of the evidence available, this goes on to page 1964, and with the reservation that it was subject to alteration in conformity with further medical experience, as a safe basis on which it would be possible to work out appropriate dust suppression methods. For this purpose, therefore, the conditions arising from flyer spinning carried on without exhaust, so without precautions, without exhaust, under good general conditions, was considered as the safe criterion and was termed the dust datum. The application of the dust datum is considered below. In fact, we don't have the below. But that was the origin of what was termed the dust datum level, which was founded on the sort of experience experienced by spinners, and was an argument that was run at one stage, or was thought to be run, that whether this is almost like a hygiene level for the 1930s, this dust datum level. It was never been matured into an argument that's been put before the court. Nevertheless, it's quite clear that there was a level at which at that time they thought that there was a safe exposure to asbestos. And that's totally different to what my friend is saying. He's only really taking you to the 5-year point, but this document says an awful lot more than that. And that's the origin, we say, of the dust datum level. Lord, just to build on that point further, we also say that actually Dr. Merriweather was right in so many ways, because what we're looking at in this case is obviously exposure before 1965, when only asbestosis was the foreseeable risk. So one has to, for the purposes of foreseeability, we say strip out mesothelioma from the thought experiment that one has to go through. Although that's very difficult, and in many of these cases, there's an understandable conflation, as I'd suggest Mr. Steinberg has gone through, between mesothelioma and asbestosis. But if one is assuming it's just a question of asbestosis and foreseeability of that, then we get to some interesting conclusions. So the first one is this: if I was to ask a doctor today, was the level of exposure that the claimant in white exposed to, did that give rise to foreseeable risk of asbestosis? You would say no.
In that case, what was your premise?
If we're forgetting about mesothelioma, and because we're pre-65, so we're doing a thought experiment.
If you'd asked the question, pre-65, does Mr. White's level of exposure give rise to a risk of injury? The answer would have been no.
Yeah, but also, Lord, if you ask that question today and say, is there a risk of asbestosis from the activities that he was undergoing, or if he was doing them today, the answer would still be no, because there is a safe threshold level, which I'm going to just take your lordship to in a minute. It would still be no today. I mean, it may well be there's no safe limit for mesothelioma, although that is an argument that's been explored in Bannister through epidemiology as to whether there is a level at which it's not causative. But even today, it's not foreseeable. So the way I'd illustrate that very quickly is to look again at Mr. Justice Swift's decision, but this time in Sabin, which should have been added to your bundles, my lord. It's the...
I don't want to... I think this is relevant. This appeal are not being run on the basis that any contribution, because asbestosis is a divisible disease, is at least potentially relevant to the contraction of asbestosis.
Yeah.
But it could have been. I'm not inviting anybody suddenly to change the basis of the appeal, but I mean, on current, just picking up on your last question, your formulation of the last question, if you ask the question now, would his exposure carry any risk in relation to asbestosis? Although the answer would be, on its own, it wouldn't be sufficient, you might have to go and have a look at Holtby and say, yes, it could contribute,
Well,
provided it was accompanied by plenty of other, which we don't have.
obviously, there's two different questions here. There's foreseeability and there's causation.
Yeah, but I was just picking up on your question. If asked today about Mr. White's exposure and asked the simple, straightforward question, the question is too simple. Does this give rise to a risk of asbestosis? The proper answer would be not on its own, but in conjunction with other, it could be contributing.
I'll take it, your lordship, as it were, to the level you need to establish asbestosis in the judgment of Mr. Justice Swift. But it's so far below; it's 1,000 times below the criteria.
On its own, it's clearly inadequate. But subject, that's my provisional view.
Obviously,
For myself.
What one is looking at is the question of foreseeability in these circumstances. And if even today it's not foreseeable, I could do that essentially for 20, 30 years, have it on a lab desk, and it's not going to cause me asbestosis. I still say that it's a kind of cross-check to say, well, hang on, in the 1950s, you know, I for sure.
Briefly going off the tangent, do we know today whether there is a rate of elimination of asbestos fibres?
Well, my lord, there is a rate of elimination. Don't know what that is, but
there's no safe limit for mesothelioma.
Not for mesothelioma.
So for asbestosis, there might still be some level below which asbestos fibres are eliminated over time.
No, so Sabin should have been added to your bundles or sent through separately. It's 1357. We have got separate.
I think
Oh, sorry, I
I
think there were
did
cluster
have
plots.
Sabin added to mine, yes. So, sounds so my lord's been discriminated against.
So, Lord, do your lordships have it?
I have it.
I do too.
Well, we can probably hand.
I had it separately as a clip up here. I don't know if my lord
Mr.
has
Kent, just
I had it a day or two ago and my clerk put it in my bundle.
Sabin?
Yeah.
Well, I may have it.
My lord, I'm only going to take you to three short paragraphs. Paragraph 1357, sorry, page 1357, paragraph 32, which is headed evidence relating to the threshold asbestos dose level giving rise to a risk of asbestosis. Paragraph 32 says there is evidence as to the level of asbestos dust which gives rise to a risk of asbestosis.
It says dose, but that's a slip, is it?
I think
No. You read dust.
Oh, did I? Sorry. Yeah, sorry. Dose, which gives rise to the risk of asbestosis. Thus, having reached a conclusion about the deceased's likely asbestos dose, it is possible to compare that dose with that level. The Royal Commission in 1984 in Ontario examined the available evidence and concluded that there was a threshold level below which an individual exposed to asbestos was not at risk of developing asbestosis. They stated that their best judgment as to the lifetime occupational exposure to asbestos at which the fibrotic process could not advance to the point of clinical manifestation of asbestosis was in the range of 5 mil years and below. Professor Dole and Professor Pito, in their authoritative paper, Effects on the Health of Exposure to Asbestos, published in 1985, saw no reason to disagree with the Commission's conclusion. In the CAP PPS report, to which see paragraph 42 below, states that clinical asbestosis can be induced by cumulative exposure amounting to an estimated 5 mil years, while research in China, US, and Germany suggests that subclinical asbestosis can result from a dose as low as 5 mils. And then in paragraph 34, there's a debate about if you've got mixed fibres, whether it's higher or lower, which I don't need to take your lordships to. So obviously, 5 mil years is the total dose that has been experienced by a claimant. And in our case, the total dose was 0.2 to 0.4 5 mil years, which is 1,000 below that 5 mil year dose. The point I make is not so much to try and calculate how close the dose was to the, as it were, the causation level, but really to raise the point about foreseeability. That if even now we know it's not foreseeable at this sort of level, even 50 years ago, they were thinking in pretty much the same way, as we can see from all the hygiene levels that were proposed, which aren't that far away if you think about it. 35 mils is about that sort of level. Now, I'm not suggesting that the reasonable employer had that degree of knowledge, but I'm still saying that when my friend says, well, the slightest whiff of asbestos dust should have triggered an employer, I mean, it doesn't, as a matter of fact, make it foreseeable at all.
If we haven't been sent that authority, which I may or may not have in hard copy, could we be sent it electronically?
Yes, certainly do that now. Just one other point to make on this. In the Cuthbert Engineering bundle, there's a document, that's their supplementary bundle 2. There's a document entitled Problems Arising, which was written in 1967. I do say again, it's a useful observation. On
Page you in?
sorry, no, it's page 147. It's on the right-hand side, and it's paragraph 21. The copy's not very good. I've actually copied mine. It's paragraph 21, where the authors say. So just to, I don't think anyone's introduced this document yet. This is Problems
The
Arising.
document was referred to yesterday.
Oh, was it?
Because I brought a flag against table 5.
Oh, Mr. Kent took it to the system. I just want to take you to one paragraph, which is in paragraph 21 on that page 147, right-hand side, where the authors say, we note, however, that at the present time, there is no evidence pointing to the occurrence of significant asbestosis elsewhere than in those identified industries where asbestos is extensively used. Clearly, this opinion is not to be applied to the problems of certain other effects of asbestos exposure, notably development of mesothelioma tumours. So, again, historically, asbestosis was certainly not a problem seen in hospitals or lab workers. It was really only related, and when we come back to look at a little bit more of the literature, it was really only related to blue-collar asbestos working in certain processes that were, for instance, covered by the regulation. Then I obviously don't want to trespass on grounds that have been covered by others, but I did very briefly want to look at the 1931 regulations, because once one understands Merriweather, then they become, I would say, more understandable. All the exemptions have been, so I'll just refer you to where they are. Authorities Bundle, tab 32. And this is page 1290. So I won't trespass over ground that's already been covered, but a number of points we say arise. Firstly, it applies only to factories and workshops and to particular processes. It clearly doesn't apply to a hospital. It doesn't apply to any white-collar employment at all. It's clearly directed to particular processes, most obviously seen in the industry, but may apply elsewhere. Secondly, obviously the 8-hour exemption has already been covered, and there is, if your lordships are interested, there's a useful discussion in Hawkes at page, which is at page 1034 in the authorities bundle.
Is that the same as warm lugs?
Yes, yes. Paragraphs 84 and 85 about the nature of those exemptions from what the regulations covered. So it didn't, for instance, include stripping off lagging, but it did include mixing. But I won't take your lordships to it, as it seems to me unnecessary to do that. But there's that exemption. But then the other, obviously, exemption that has not been referred to by anyone, and in fact, Mr. Rawlinson's case seems to be the opposite, is that, as you can see from page 1291, it applies only to occupiers. It does not
Only
apply
to what, so sorry?
The regulations, as you can see from 1291, apply only to occupiers. It doesn't apply to employers per se. And yet, Mr. Rawlinson's case, as I understand it, is no, the duty would arise on employers, but not on occupiers. But actually, the regulations only apply to occupiers. And I do say that's...
Well, sorry, I'm being slow. Why does that make a difference?
Well, Mr. Rawlinson's point was, I think he was saying that the nexus between an employer and employee is such that there's an enhanced duty.
Oh, I see.
And what is odd about the regulations are that they don't apply to employers per se. I mean, clearly, the occupier...
I'm assuming that the concern might be that if you are running a workplace with asbestos processing in it, you might have people working there who were not your employees. They might be employees of an associate company, or they might be visitors, or they might be independent contractors.
It's odd because part 2 is obligations of persons employed.
Those are the...
I've never noticed this.
Yeah, on the actual employees.
So as it were, from the management side, or however you like to describe it, the responsible side, it's occupiers, which would normally cover employers, but arguably doesn't if people are just working outside. Well, people are working outside and cutting up bits of soffit,
Yeah.
which is, I know is not.
But it obviously, this lacuna was dealt with in the 69 regulation that applies to all employers.
Yeah.
But I just make that point that the exemptions are again obvious when one looks at the regulations. And clearly these regulations stayed in force until 1970 when the 69 regulations came into force. I did then want to look at the asbestos industry scheme very briefly, my Lord, which is on tab 33. And take Lord Justice Stuart-Smith to his favourite topic, which is the Workers' Compensation Act.
I think I've managed to forget everything that I ever knew about workers' compensation.
We spent many weeks in trigger litigation debate.
It would be most unkind of anyone to remind
me. So the point about the regulations are that they mirror almost exactly, if one looks over at regulation 2 and 3, the exemptions and structure of the 31 regulations. But as far as the other provisions are concerned, if one looks on page 1296, one can see that the restrictions that do apply to claiming under the scheme. Obviously, the Workmen's Compensation Act was not a common law framework. It was essentially what was a scheme, a statutory scheme for recovery. But at subparagraph 4b, you'll see that the no compensation shall be payable in cases where the workman has not been employed in the processes or has been in receipt of weekly payments under the scheme at any time within 3 years previous to the date of injury. So if you're not employed in the processes for more than 3 years, you don't get in. And then paragraph 5 was the point my Lord made to Mr. Rawlinson. If the workman has been employed in the processes for a period or periods of magnitude not less than 5 years, the disease shall be deemed to be due to employment in the processes unless the employer proves to the contrary. So it's a presumption that if you've been employed for more than 5 years, it was caused by the processes, but less than 5 years, you don't get any statutory presumption, and the employee then has to prove causation in those circumstances. The way he would do that, just for your Lordship's note, is the procedure for settling questions is Regulation 14, which then triggered an arbitration mechanism under Section 21 of the 1925 Act. So, again, there's this exemption because it is seen, we would submit, that short-term exposure is not commensurate with certainly compensation under the Act. Then, jumping on in time to a document you were taken to by a learned friend, Mr. Rawlinson, the 1938 report. It obviously has had a lot of airplay in a number of decisions, and I did, as Mr. Kent said, I did want to just put this in its proper context. The letter itself you've looked at, Lords, which is in Cuthbert bundle, page 89, but I wasn't going to ask you to look at that. I was going to ask you to look at the full copy, which is in the literature core bundle in white, and it's at page 45.
Page 45.
Page 45 of the core literature bundle in white. It should be entitled Chapter 4 Health. The first point to note, it's a small point, but one I do nevertheless make. It's often said that this was it's an expression highly. It's really the colourful term highly dangerous. That's
Sorry, I just didn't hear what you said.
Sorry, my Lord. The page reference is page 45.
Got that, yes.
Yeah.
You said it's often said.
It's often said that this was what the chief inspector said in the report. Well, yes, in a sense that's true, but actually if you look at page 45, you'll see that it's an article written by John Bridge, who's a senior medical inspector. And he's going through all the different types of diseases that he thinks are relevant to the job that he's been asked to do. And then if one looks on page 63, one can see that there is a reference to dust you were taken to. This is page 63, and about 10 lines down, the only reference to asbestos is that one sentence. It's not many years ago that when dust of asbestos was regarded as innocuous, while today it's recognised as highly dangerous. And then he stops there and he goes on to start talking about, but we're doing very well in aluminium for flint production in the pottery industry. I mean, it's one sentence in one article written for the purposes of the report. And no doubt it was influenced by the fact that a few years before, asbestos had been seen as this wonderful material. And now he's saying, but hang on, we've just had Meriwether and Price, and it's dangerous. And I think there's so much overread in the laws that's been read into the fact of highly dangerous. All he's saying is, we've got Meriwether and Price. We now know that this material can be dangerous when we thought it was innocuous. That's all he's saying. And my friend's wrong when he suggests that the Tubercle article in some way changed the terms of trade and made the chief inspector use this language. It does this, in fact, if anything, it should have caused him to be less contentious than he was. But the idea that we've got a single sentence in this document in 1938, and in some way that changes everything. It's not even addressed, obviously, to the hospital. This is purely for factories. So you would never have come to the attention of a hospital, one would have assumed.
Who does it go to?
Factories.
No, it goes to the
Well, Parliament as well. But
It's an annual report, and
one assumes that
formally, it is simply sent. It is simply presented to. Well, presented. Well, actually, it's presented by the Secretary of State to Parliament,
Yeah.
and unless anyone draws our attention to it, there's no particular obligation to circulate it. People interested would no doubt buy a copy to Bob, and put it in their libraries or their experts to be able to read through it for anything relevant. But it would not be. It's not generally circulated. It's not guidance. Is that right?
No, I think that is correct. I mean, normally the way one treats it is that factories might be expected to take cognizance of what's in an annual report, big organisations, but even that may be pushing it too far in an age before the internet. But the key point is that it's being used and recycled in a lot of asbestos authorities as almost changing what was known at the time of Meriwether and Price, and it's just not doing that. It's one sentence that reflects Meriwether and Price, and we've already looked at that. So I do say that it's subject to a continual overread in a lot of the authorities, particularly as Mr. Kent pointed out, asbestosis, which is on the comparative table on the next page, on page 48, there were 9 cases in 1938, which represents 1% of all the cases of fibrosis in the country. And this was a document presented to Parliament, I think, in 1939, in fact. The very year when, obviously, this country went to war and everyone was walking around with crocidolite gas masks, including babies. And so I do say it doesn't change anything to that extent. So there are a number of references that I don't wish to trouble the court with in terms of what was happening in the 1940s. But if one looks at them, Mr. Kent's been through them all, they really only relate to industrial processes, blue-collar type work. They don't deal with the sort of circumstances we are looking at here. And in fact, one looks in vain, and my lord, the Vice President's question about there's no guidance to, as it were, end users of asbestos anywhere is actually very pertinent, because during the 50s they started building schools, class schools out of asbestos, and it was used everywhere, and nowhere is there any sectoral advice to anyone suggesting you shouldn't use asbestos in doing all this. All that the friend can point to is this high level asbestos is dangerous type of approach, but no advice whatsoever, as it were, what one might term as bespoke. I do say that the absence of evidence is striking in these circumstances. Mr. Kent's already taken you to quite a few of these. I did want to take you, my lords, to just one point in our evidence, just to fill in the details from the 40s to the 50s, which is in Mr. Hewson's report. And that's at page 71 of our supplementary volume. what Mr. Houston has, or Dr. Houston has done there is that he set out the various annual reports, and you'll notice if one goes through a lot of the authorities that you get the 1949 annual report, and then it's almost silent for almost all of the 1950s. There's no, I mean, there may be, I think there's one document that's occasionally relied upon, but there's nothing really going on in the world of asbestos litigation in terms of warning anyone about it or making comment on it, apart from the emergence of asbestosis leading to lung cancer in 1955. What Dr. Houston says at paragraph A 2.2.16 is, in 1956, the Chief Inspector of Factories in his annual report reviewed the effect of the asbestos industry regulations in 1931. And he commented, on the whole, there has been, as a result of a fuller realisation of the hazards by occupiers, a general improvement both in premises used and in the standard of compliance with the regulations. This statement suggests that the enforcing authorities at the time, i.e. the factory inspectorate, thought that through the actions taken to comply with asbestos, that should say industry regulations 1931, they had asbestos-related disease reasonably well under control. Little further advice concerning health risk came from government agencies, i.e. the factory inspectorate, to industry around this time, as they were satisfied that as regards exposure to asbestos specified, no major problems existed and things were under reasonable control. I would submit that that is that omission is important. And then Dr. Houston says, if one goes back in his report to page 47, he then discusses very briefly this, just to deal with one point of this raised by the Lord Justice Stuart-Smith at paragraph 6.4.2. This is paragraph, sorry, page 47. That's where the expert, where Dr. Houston says, in my opinion, during the early 1950s, there was no published exposure limit value for asbestos, though HM inspectors of factories would have referred to the US ACGIH, American Conference of Governmental Conference, I think, of Industrial Hygienists, threshold limit value of 5 mpc/cf. I'll refer to Silk, HSE 1983, who wrote, standards for concentrations of toxic substances in air are known in the United Kingdom's threshold limit values. Since the 1950s, they've been published by the inspectorate as a working tool for occupational hygienists engaged in measuring the extent of the hazard and assessing the risk. And that was the basis on which the judge made the finding in the 1950s, as well as the other points that I just took your lordship to. Similar, that leads us on then to the question of these threshold limit values. You've obviously been taking the 1960 version and I think the 65 version. I did want to mention the 1959 report of the factory inspectorate that I think shows what they were intended to do. That hasn't been referred to yet. That's in the white core literature bundle at page 141. And if your lordship sees, it's the right at the bottom of the the page, concentration of the dust. Where the author says there are many variables involved in it. Sorry, there are many variables involved in relating exposures to different concentrations of dust and the lung response which may follow. It is necessary, however, to have some guide to which the efficiency of control measures can be related, and the department has accordingly recently published a booklet containing a table based on the latest scientific knowledge showing the maximum concentrations of certain dusts expressed as particles per cubic centimetre, which, if exceeded in factory atmospheres, indicate that working conditions cannot be considered to be satisfactory. So, if exceeded, they cannot be considered to be satisfactory. So, I do say that that was certainly the intention of the inspectorate in 1960. And it is of, I say, of therefore considerable import And even if it's not a red line, which we're not suggesting, the fact that we're 1,000 times below that limit is something where we can take reassurance from it. Then if we stay in this bundle and look at the document itself, and because it's been covered, I'll jump through quite quickly. It's page 160. Sorry, 152, my lord. Under introduction, toxic substances in the factory atmospheres. It's just the first paragraph I'd ask you to look at because it's, I would say, been the subject of some misunderstanding, and I see the way my friend's putting it. The way in 1960 it's written is, by section 47(1) of the 1937 Factories Act, all practicable measures are to be taken to protect persons employed against inhalation of any dust or fume or other impurity of such a character to such extent as to be likely to be injurious. Now, what we say is that the natural reading of that is that the trigger is that the dust has to be likely to be injurious or substantial, not that one takes these steps and then decides. The trigger is that it has to be injurious, and then they say, and if it is, you've got to take reasonable practical steps to deal with it, and here are all the ways you can do it. And we say that's clear from a number of factors. The first one is on page 153, on the bottom right-hand corner, where it says permissible concentrations. The fact that the word permissible is used, the clue's in the name really, but on 4 lines up from the bottom, the authors say, if this concentration is exceeded, further action is necessary to achieve satisfactory working conditions. So again, the trigger is that if the concentration is exceeded, further steps have to follow. And one final point just to make, as I said, it's been covered by another phrase, but just on the actual limit itself, that's on page 157. The Lordships can see under mineral dusts, asbestos is in the top left-hand corner at 177 ppcc. And it's clearly treated differently from other dangerous materials. So if one goes down to the bottom right-hand corner, you can see pentaborane, which has got 2 stars. And the very bottom footnote says, until more data are forthcoming, it's important that atmospheric concentrations of these materials to which workers are exposed must be kept near 0 as possible. So there clearly is a hierarchy here, where things that are seen as very dangerous are then given a 0 rating. Pentaborane itself, I think it's a volatile compound. It's like rocket fuel. I can understand why you have to be careful with rocket fuel. So we say that our reading of the introduction and its use under the Factories Act must be correct, particularly because of the key passages that you wanted to take you to in both the 65 and the 68 edition. So the 65 edition is on page 210. Which I think you were taken to this yesterday, but just to the first 4 lines I wanted to take you to. Under the preface, it says the threshold limit values. Sorry,
So which page?
page 210.
Sorry, the way it's been.
It's again irritating because it's on a landscape format.
So a landscape format where the type goes over the number, but I found it 210 years.
The preface says the threshold limit values refer to airborne concentrations of and substances and represent conditions under which it is believed that nearly all workers may be repeatedly exposed day after day without adverse effect. So, I mean, that's unequivocal in terms of, I would submit, that the sort of weight being put on the concentrations. And that, that view carries on to 1968 with the same, almost the same limit for asbestos. So if one goes to page 269, and thankfully this is in portrait and not in landscape mode, that's in tab 15, page 269. And again, with that same rubric is used at the top under preface about day-to-day, it's safe, believed to be safe day-to-day and day out without adverse effect, top of 269. What happened in 1968 though was that there was a notice of intended change, which we can see on page 288. And your lordship will see. So yes, 288. And this is 1968. So under asbestos, it's got 5. Again, this is MPPCF, but that's still 35 mils. But if one sees the 2 stars there, go to the bottom. It says see notice of intended changes, and then over the page, your lordship will see that the notice of
That's the
intent.
177.
Sorry, Lord, I'm looking at page 288.
Yes, but it's the equivalent of
Oh, sorry,
177.
177. Yeah. And if one goes then over to page 291, you'll see it right at the top there under substance. It says asbestos. So the limit is proposed to be changed to 12 fibre mils, 5 microns in length, or 2 MPPCF, which is the equivalent of 12 fibre mils. So we're still well above the limits that were ultimately imposed. But that was the proposed change in.
But, forgive me. What does 12 relate to? 177.
No, 12 is 12 fibre mils. So we're into the conventional expression of quantity in on page 291. So what had happened before was that they were using the American expressions of volumetric measurement. Now they're moving to
Which was
British one.
MPPCF.
Yes.
And 5 MPPCF was the equivalent of 177.
There or thereabouts, which is the equivalent of 30 fibre mils. We put that in that table, my lord, that we handed up.
Yes, thank you.
So
So it's 12 compared to 30.
yes, so it's come down to 12. It's still obviously looking at it from modernised 1968, still quite high. And ultimately, what happened was when the regulations came in, TDN 13 came in, it came down to 2. So this was actually never enacted, but it was a notice of proposed change. Then I'm conscious of the time, lords. One other point I do want to make. I wasn't going to intend to take you to. Well, maybe I ought to take you to TDN 13 just very briefly because it does illustrate the last point. That's on page 301. So the standards to be used with the asbestos regulation item 69. And what the claimants say is, well, this is just almost like a prosecution note as to when the inspectorate will get interested in exposure and it's not a safe level. Well, if one reads it carefully, the first 6 lines, it says, in this note, guidance is given as to how HM Inspector of Factories will interpret the expression dust consisting of or containing asbestos to such an extent as is liable to cause danger to the health of the employed person. So it's talking about an interpretation as to what is necessary to cause danger. I would submit it, for the reasons set out in Williams and as qualified in Bussey, it's more than simply guidance to HM inspectors. It's an attempt to avoid danger to people exposed to asbestos. It's inconceivable that the inspectorate would say, well, this level is going to cause danger, but we're not going to prosecute unless you get to higher. So I do say it goes beyond that which is being argued by the appellants. And that view is finally condensed in a document on tab 18, at page 344. Which is an article called Threshold Limit Values for Environmental Monitoring and Hazard Assessment and Control, written by Mr. Luxon, who we looked at before, who was involved in the BOHS, so he's factory inspectorate. This is 1973. Now, this document, my lords, was not in front of the Court of Appeal or used at the trial in Bussey. I think Mr. Glenn's report, who was the expert there, his report was only 8 pages long, at least I think, because I have seen it. And he didn't refer to this. And I do say it's highly material. Page 346 is the extract. It's the third line down there. Where Mr. Luxon says, fourth paragraph down, sorry.
You were taken to this.
You've been taken to it.
Were we? Oh,
No, I don't think you were.
I haven't marked it.
I don't think so.
Oh, it must have been my natural enthusiasm.
Well,
Are you starting it for the purpose?
no, I'm sorry, legislation.
Okay.
Just one paragraph. Legislation controlling the hazards of inhalation of toxic substances generally is contained in Section 33 of the Factories Act 61. This requires that where dusts or fumes, include vapours or gases by definition, are present in the air of the workroom to such an extent as to be likely to cause injury to health, steps must be taken by exhaust ventilation or other means to protect her. For the purpose of determining what concentrations might cause injury, the TLV is now generally accepted as the yardstick. If, therefore, it can be shown that the TLV has not been exceeded, then the employer's legal and moral obligation can be said to have been fulfilled. And I do say that the way in which that's phrased is highly material, the legal and moral obligation. So certainly the view of Mr. Luxon, who's a senior inspector at the FI.
I'm not giving up yet. You cited that in your skeleton.
I did. That
That is, my lord's just showing off how carefully he pre-read, and showing up that the two of us didn't follow up this reference.
I do say it encapsulates the importance, particularly of TDN 13, but of hygiene levels generally.
Can I,
Yes.
for no, it's just been bugging me, couldn't matter less. At page 301,
Sorry, is this in the
the same bundle, in TDN 13, there's reference to procrylolite and amazite, but also something called chrysotile. Is it just a typo for chrysolite?
That's chrysotile, my lord.
It is TILE, not LITE. Oh, well, there you are.
Just chrysotile. Yeah.
Chrysotile. Okay,
Yeah.
thank you.
Yeah. So, Lord, I've left myself about 10 minutes, I think, for the. Sorry, one point I ought to make, just to put down a marker, my Lord. In Maguire, Lord Justice Longmore purported to interpret this guidance along the lines of, well, you have to take all the reasonably practical precautions before you look at the permissible concentrations under the TLVs. And that's clearly obiter, and I just say it's wrong. It's clearly not the way you read these documents, not when you look at the contemporaneous.
Well, sorry, if this is important, we'd better look at it. I don't quite. Where does he say this?
Well, it was raised by a learned friend in his submission. So if we.
Oh, well, I'm sorry if I didn't take it in.
So, Lord, if one looks at Maguire, which is probably the most difficult case in all of these cases, because the three judges say three different things.
Yes.
But it's tab 14, page 515. And it's in the judgment of Lord Justice Longmore. And obviously, my lords, the the key point about Maguire is that the ratio of the case is simply that secondary victims couldn't claim pre-65, and that's the ratio. Everything else is obiter. And then Lord Justice Judge gives a view which we support for the reasons set out in our skeleton argument. Lord Justice Longmore diverged at certain stages while being in the majority. And I'm just trying to find where. It's at page 546. Well, if one looks at 545, first of all, so just to set it up, your lordship will see that Lord Justice Longmore deals with the 1960 booklet.
Sorry, which page 5?
Sorry, 545.
Yeah.
A paragraph, sorry, line 90. He deals with the 1960 booklet, which I've taken your lordships to. And then he goes over the page. He says, he recites the preface that I took your lordships to, and he says, in other words, at the top of page 546, it's only when it is impracticable to reduce exposure to dust that the permissible concentrations can have any relevance in relation to employees. I just say that's wrong. It's obiter, it's not correct. It's different to what Lord Justice Judge said at paragraph 32. I do say also it's contrary to what Lady Justice Hale said in Cherry Tree, because she took the limits as being valid, given the finding of the...
So, sorry, just, which is the paragraph which it contradicts in Lord Justice Judge?
32, my lord.
Right.
Step to 77 as well. Are you there?
I'm asked, sorry, 77?
77, please, yes.
You'd like me to read 77? My friend is asking your lordship to look at paragraph 77, which is, I'm not going to read all of it because I'm short of time. But
Depends which of your learned friends it is, because if they've got a right of reply. If they...
all of the comments that are made in 77 are obiter in relation to the use of TLVs, and they...
This is in Lord Justice Manson's judgment.
Sorry, I'm right. That is Mans. So that's the dissenting judgment. So I'm not intending to refer to that, because what Lord Justice Mans had to do was, his view was that the claimant in that case could succeed on the basis of foreseeability. So he obviously had to take the view that in the circumstances of that case, you wouldn't look at TLVs because he thought the decision in Owen was correct, but he was dissenting. The actual ratio of the case is that secondary victims can't recover pre-65. And also, in addition, Lord Justice Judge made the important observation, which I think Lord Justice Newey referred to in argument at paragraph 40.
Who was it who was asked you to read para 77?
It was me, my lord, forgive
But
me.
didn't you take us to it yourself in your opening?
I did.
I'm not quite sure why we need to be taken to it again.
Well, forgive me if you didn't assist. I shouldn't have done it from a sedentary position in any event.
I'm going to 48. So I was going to take your lordship to paragraph 48, and the last 6 lines, lines into it.
Which oh, I see. Well, Mr. Kent took us to the last 4 lines, but you're going to give us the rest of paragraph 48.
So it's the sentence starting. However, in this case, it was not established that the dust to which Mrs. Maguire was exposed to effectively replicated her husband's level exposure, nor indeed that her level exposure, if repeated in factual conditions, would have constituted a breach of duty by the employee.
Mr. Kent did rub our noses in that.
And Lord Justice Longmore doesn't seem to dissent from that. I mean, one can suggest he did, but the ratio of the case is that she couldn't succeed as a primary victim. There wasn't a degree of foreseeability there. She therefore failed as a secondary victim. And that's the key ratio of Maguire. And I do say that the opinion of Lord Justice Longmore is not correct. It's inconsistent with Hale,
said that, yeah.
Lord Justice Hale, Abraham, and actually it's inconsistent with Watson, Williams, and Bussey in terms of how one looks at these threshold limit values. That's that, Lord. So that is. I've got 7 minutes left. So just to.
Well, I suppose you have, although you got a longer start than you thought.
Yes.
So, I mean, I don't think you feel you've got to fill up till 4 o'clock.
No, my lord.
But if there's points you want to make, we won't stop you.
Yes.
Feel you must, feel you should make.
Well, can I then deal very briefly with Cherry Tree, which has been well canvassed, but an argument that we put in our skeleton I don't think has been canvassed, which is on page 425, paragraph 51 and 52.
Yeah, but it's not confusing when people call these cases different names.
Sorry, my lord.
We spent the whole time calling it Jeremson, and you're going to call it Cherry Tree.
It was known as Cherry Tree for a period, and then
Oh,
it
was it? I see.
swapped to
Right. Okay, and we have it. Yeah.
Now, the suggestion that is being made is that Lady Justice Hale preferred the judgment of Mr. Justice Buxton and Owen to that of Waterhouse, Mr. Justice Waterhouse in Gunn.
Yes.
And that's based on paragraph 51.
Yes.
Now, what we say is that that's not correct. What she did do was she supported what the trial judge said about heavy and intense exposure not being the rubric by which foreseeability could be established. But all she does in 51 is to set out the competing views of Mr. Justice Buxton and Mr. Justice Waterhouse. She doesn't say in terms that she prefers and endorses what Mr. Justice Buxton says. And of course, this was a case of heavy exposure where the exposure was in excess of the threshold limit values in 1960 anyway. So we could understand why she came to the view that the trial judge was entitled to come to the view that he did. And if one looks then at the bottom of paragraph 52 on that same page, she says in the last sentence of paragraph 52, there is no reassurance to be found in the literature that the level of exposure found by the judge in this case was safe, and much to suggest that it might well not be so. Judge was entitled to conclude that a prudent employer would have taken precaution. So she's not saying no level of exposure is safe. She's saying that the level of exposure found by the judge was not safe, and it was in excess of the TLV. So one's hardly surprised by that that comment. Lord, I think those are all the submissions that I have to make. Bearing in mind the time we've allotted ourselves, are there any other matters that you would like me to deal with?
My case not. No, thank you very much indeed, Mr. Platt. I should say, I think I said something before lunch which I didn't mean to say, to the effect that, which may have been understood as saying that Mr. Steinberg would have no right of reply. Perhaps you didn't understand it that way, but
I didn't, my lord.
No good. I think I was in the context of saying you ought to deal with the respondents' notice points now.
Oh, yes,
but good.
in a general hurry up thing.
Fine. Right, now, I forget how you divided, which of you was going to go first, as between the two of you.
No, from Mr.
Well,
Steinberg first.
I will be extremely brief. I have 3 short points in reply.
Good.
The first one is that during the course of argument, my Lord the Vice President referred to an authority which possibly questioned the relevance of the guidance of a regulator. My Lord,
Yes, I did. I had a faint recollection, but
I suspect it's Stokes. You have been taken to it by my learned friend. It's, for your note, it's page.
just show us the passage,
It's
and then we'll see whether it's one.
page 99 of the authorities bundle, going on to page 100. It's the marked passage.
Yeah, that is exactly the passage I had in mind. Thank you.
Well, the second point is very, very briefly in response to what my learned friend has just said. We say that any fair reading of Jeromson suggests that the judgment of Lady Justice Hale wasn't just repeating and accepting that the judge was right to accept. Any fair reading we say is that that was her preferred view. You've been taken to, I won't take you to any more passages, but we said that's as a whole, the case suggests that. And finally, my lord, in response to a point put by Lord Justice Stuart-Smith, material contribution does play a part of our case, part of our appeal. Because what we say is that because the employer didn't know what else would happen to this man, it could have played a part in the contribution of that illness, my lord. So it is part of our appeal. My lord, that's all I have to say. And my learned friend is going to reply on that.
That's very helpful, and you've got another brownie point for a very succinct reply. See how you can do, Mr.
May I cash in my learned friend's brownie point?
They're non-transferable, I'm afraid.
My lord, dealing with things with absolute speed. In terms of the nature...
No, I'm being facetious. Of
No,
course, you must take the time you need, but within the
But
limits
I'm
available.
anxious to signal I'm not just going to retread.
Yes, good.
In terms of the nature of the relationship between the employer and the victim, importing with it a greater series of aspects of scope. Mr. Platt suggested that there was some dilution to that argument by the fact that the Factories Act refers to occupiers.
Yeah.
My lords will have the point that in fact it is a complex piece of legislation, and that I'm afraid I've only got it in my memory from the 61 Act, but I can be absolutely certain that the precursors in the 37 Act, for example, there are circumstances where the factory owner is deemed to be the employer of somebody that comes into the factory, that's section 1755, where there are two or more people from an outside body coming in, and they are deemed to become the employer. And that mechanism is important because it needs to be understood that all of these relationships are because of control. And that's why there's no special word about employer, it's just because there is that level of control. Building on that slightly further, in terms of whether it was right to say that a very large organisation like Taylor Woodrow in my case should have been aware of Chief Inspector's report, it should be noted that of course what the deceased was engaged upon were works of building operations, and of course that triggered the operation of the Factories Act. And so the sector regulator for the work that he was doing was indeed the Factories Inspectorate. And that was put to Mr. Phillips, sorry, forgive me, Dr. Phillips, by my friend Mr. Archer, and the reference to that is at the Supplementary Bundle 1, Divider 1, page 64, capital G. In terms of two other pieces of regulation guidance for the construction industry, we've already referred to the 1949 HMFI report, which refers specifically to work upon buildings. And the reference to that is the second supplementary bundle, Divider 16, page 99. And then a document that my learned friend Mr. Kent took the court to today, which is in the Department of Enterprise and Productivity, forgive me, document that is in the white large bundle of background materials at page 650 in the written page.
Page?
650, please, my lord. My lords will recall...
That's volume 2.
I'm obliged. You went through with Mr. Kent.
Wait, I won't recall
I'm
it
so
till we found it.
It's all right. Yes, sorry.
I have 650, yes. As you say, we went through bits of it.
Indeed. But to the right-hand side of the page...
Which page?
Of 650.
650.
I don't recall, and forgive me if I missed it, that there is a reference to the building trades expressly set out in the table above the number 2. And my lord may see the word building trades, and to the right of that, trimming of asbestos, cement sheets, and insulation.
Ah, yes. No, I think that's my fault because I deliberately took him, because this is what I saw, to 2
Yes.
and to large building projects.
Yes.
Yes, I see.
And sorry, I've lost the reference to building trades. Where?
Can my lord see
Oh, I
it?
see. Yes, I do see it. Yes, yes.
I knew it was oversight. It was just so that you have it.
No. Well, it wasn't. But it wasn't oversight. Yes, okay. Let's just.
In terms then of the references to how one deals with toxic substances and indeed TDN 13. And forgive me, I shouldn't have done it from a sedentary position. I
No,
apologise.
don't worry at all.
But the
Honestly.
my friends used to be heckling, but not in usually such august circumstances. The reason why I was asking for attention to be redrawn to paragraph 77 was because my lord had said that he hadn't
Again,
recalled-
sorry, I was just marking up where we were before.
Oh, I'm
Where have
so
we gone to now?
I should have said, forgive me, it is the bundle of authorities, second volume, divider 14, page 541.
Thank you, Tom Maguire.
Yes, but,
Yes.
77.
77, please, yes. And this is the minority judgment of Lord Justice Mance.
Yes.
But because if you start about 12 lines down with the words "because of the general uncertain," you'll see that actually his thinking is, to my simple mind, ad idem. Perhaps there is some subtle difference, but it's passed me by. To that of Lord Justice Longmore, in saying that one cannot view the averages in any particular situation if they are lower than TDN, the toxic substances, as being in some way a form of exoneration. And one can read the next 10 lines down perhaps and stop it here as a matter of fact. And built up from that, and I finish with that authority now.
I mean, what this can't be is ratio.
No, certainly not. But what you have are 2 out of 3 members of this court looking at the documents and looking at their value in a completely diametrically opposed way to the one that you're invited to take today.
Yeah.
And
So
where
you're
is it?
saying this is persuasive,
Yes, well, perhaps.
when, particularly when read with Lord Justice Longmore.
But also when one looks to the intention of the document of toxic substances. My friend Mr. Platt, amongst some entertaining submissions about face masks, and as part of his theme, which appears to be that the absolutely egregious in some way exonerates the merely very bad. The fact that we have these sorts of face masks really doesn't help an employer in a specific situation. But if his interpretation of toxic substances is right, it would appear to be, as I understood it, that because it refers to section 47 at the beginning, and section 47 talks in terms of dust that's likely to be injurious, it doesn't really trigger any of the requirements unless you've already concluded that you have a problem whereby you are exposing somebody to dust or fume or impurity that gives rise to a foreseeable risk. And that rather drains the document of its intention, which is to act as a prospective safety guide and not a way of carrying out some sort of post-mortem ex post facto when you've already created the risk. That is not a sensible way of reading the intention behind that document.
I'm very sorry, I'm not sure I've got this. You're saying that the respondent's interpretation of that passage in toxic substances is that because of the reference to section 47, or given the reference to section 47, no requirements are triggered, so what I've written down, unless you've already concluded that you have a problem caused by asbestos. Have I got it down right?
No, forgive me, my lord. What I was saying, or intended to say at least, was that as I understood Mr. Platt, what he was saying was, unless you've concluded that you may be in breach of section 47, That is, you've concluded that you may already be exposing somebody to a substance in such quantities or of such a type that it gives rise to a foreseeable risk. None of the graded steps that appear in the rest of the document before you get to counting are triggered. Whereas we say, no, 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 this is a general prospective guide to safety. You take what's in that guide, you ask yourself in all circumstances, am I exposing myself, my employee to a poison? You go through the steps it takes towards the end of the list, and it's only at that stage that you even start to think about counting. Because it's a safety guide. Forgive me, because it's a safety guide. It's meant to be on the shop floor, used by both management and employees. We then go on to make the point, if that may move on from there, that indeed, as my learned friend Mr. Steinberg has just said, my lord may recall yesterday that when I was being asked the questions that my lord asked in respect of what would amount to the foreseeable, and I replied, amongst other things, to say, well, one of the dangers for an employer is that they do not know, once the employee leaves their employment, what their employment future holds. And their 1 or 2 or 3 notional units of exposure given to an employee may be given to an employee who then goes off and has lots more exposure, and the two in combination lead to asbestosis at the end. And that was the invitation to consider that the foreseeability test is whether you've done enough to materially contribute to the end result. And that's set out at paragraphs 49 and 50 of our skeleton. My lord will remember that we refer to Holtley and Carter within the skeleton. And that takes us to what we say when one looks again now at Jeremson at first instance for the last time in concept. I don't need to take the court to it again. This is why Mr. Machell found that the trigger was visible dust, because there was no other test. And we put it in the obverse and say, well, if it's not visible dust that is the trigger for at least asking the question, should I be doing something here? It's very difficult to be able to identify what the test could be, because you can't measure. Descriptors between ourselves, as in between the bench and the bar over the last 2 days, have been shown to be flexible, mutable, protean things. So what is the test if it isn't visible dust?
Well, it may be easier to say what isn't, or maybe easier to say when the test is not satisfied.
Well, my lord could, of course, simply approach this and say, when I stand back, do I think that the judge below was wrong when he held that the exposure to which the deceased was exposed did not give rise to a foreseeable risk of injury, yes or no? But my lord will recall our invitation right at the beginning of these submissions that it may now be time to give some guidance.
There are two different questions.
Yes. And if I can build on that, just very briefly. It links.
In the context of asbestos exposure in the 1950s, you're, as it were, challenging one to say foreseeable risk of what?
Yes.
Well, there are two possibilities. Foreseeable risk of asbestosis.
Yes.
Clearly, if the level of exposure is sufficient to give rise to a foreseeable risk of asbestosis, duty follows, not a problem. What is much more problematic, which has been floating around for the last 2 days, is whether the alternative formulation is foreseeable risk of something, clearly not mesothelioma, or whether it is the test at this point suddenly reverses and says, well, because we don't know, that you must owe a duty. And at least on conventional thinking, common law thinking, if you take out risk of asbestosis, the next question should be risk of injury. What is the foreseeable risk of injury? And you don't answer that by saying, I don't know, or we can't identify one.
No, I don't. Absolutely right, I don't, my lord, with profound respect, because the answer is clear from Jeremson and Maguire. The answer is some pulmonary injury. We're told that. Now, as it happens on the evidence, the principal pulmonary injury foreseen is asbestosis. But it's because of that formulation that it's allowable to...
No, at that time, there was no other foreseeable pulmonary injury.
Well, my lord, forgive me. I'm so sorry.
It's where these two lines intersect. You try to meet... Let's for a moment assume that there was no foreseeable risk of any other injury because no other injury from the inhalation of asbestos was known. Just take that as a given for a moment. There's two possible responses to that. One is that means there's no foreseeable risk of injury if you're below the threshold for asbestosis. The other is you say, well, although there's no foreseeable risk of injury, because we don't know, because we don't have ultimate foresight, we're going to impose a duty because we don't know. But that's not the common law.
Well, no, I certainly, as my lord formulates it, absolutely not. But there are two responses. The first is that I agree entirely that the principal injury foreseeable was asbestosis, but that itself is a very broad church. And as my lord will recall from yesterday when I was referring to Merriweather and Price, Merriweather and Price were careful to point out that the gravamen of the injury that we are calling asbestosis isn't just necessarily the mechanical damage, the scarring to the alveoli, which means that the body cannot extract the oxygen from the air inhaled, but because it takes a toll generally, which makes life difficult for the body when there is some sort of exogenous infection. And that's why I'm cavilling over whether it's just asbestosis or not. And then to go to your next positive question, if I may put it that way, my lord. I wouldn't suggest, for instance, suppose a man suffers fibrosis that is only discovered after death. He doesn't feel any difficulty, but a post-mortem shows that he had early fibrosis. He was a sedentary individual. It didn't really stop him doing anything, but what it did do was render him susceptible to pneumonia. And he died from pneumonia. He would succeed, not because of what I perceive with respect my lord fears, that this is some sort of precautionary principle, but because basic case law, like Kufos and Charnikov says, assuming you can prove causation, that the foreseeable risk of injury here being pulmonary injury, it's happened in very unusual circumstances. The employer might well have thought that there was going to be a fibrotic death in due course. They happen to have died from
Your starting point is the foreseeable risk is pulmonary injury.
Yes.
And that's difficult. It's quite interesting. I'm sure in the last 4 days I've read the word pleural plaques, but we've got this far without talking about it.
And it's such a shame, it was one of mine. I would love to talk about it.
But I mean, I think if my memory is right, pleural plaques as such were a phenomenon that were known quite early on. Whether they were known in the 1950s, I'm not sure.
Yeah.
But for example, we know that if you had a foreseeable, all you could show was a foreseeable risk of pleural plaques, wouldn't do.
Yes. But well, I should say, by the way, I was teasing Malone from when I said it's one of my, Mr. Kent led this.
Could you, just for my benefit and my peace of mind, could you once again formulate what you say if there's no foreseeable risk of asbestosis?
Yes.
What do you say is the foreseeable risk of injury?
Some pulmonary injury.
What?
Well, the phrase is some pulmonary injury. And I'm standing on ceremony on this because I do respectfully submit that my example of if the man dies because his natural ability to fight off pneumonia is compromised because of early fibrosis that he doesn't otherwise notice and doesn't impinge upon him, he would, subject to proof of causation, have a case.
But by then you'd have proved that the level of exposure is sufficient to give rise to asbestosis. So it doesn't help you at all.
Well, with respect, my lord, it depends what question I'm being asked. It does help me.
I'm asking you the same question as before.
Then it's my inability to understand, not the quality of the question. I understood the concern behind my lord's question as being whether I was in some way subverting the usual process, the usual question: is there a foreseeable risk of injury? What is the
That is
foreseeable
exactly
risk?
my concern.
Yeah. And am I in trying to some way rely on some vague notion of
I was going to say stardust.
yeah. And the answer is not. As long as what is being ascribed to the exposure comes under the rubric of some pulmonary injury, and I take that from the case law, the precise disease doesn't matter. That's why the claimants in Jeremson were entitled to succeed for mesothelioma death, where mesothelioma hadn't been heard of at the time that they were being exposed.
But does it have anything to talk about pulmonary injury here? Because the only injury that could have been foreseen was asbestosis. And if you prove foreseeability of asbestosis, you don't need anything else. But if you don't prove that, you're not going to find anything else.
My lord, forgive me. The reason why I push this is because of the subtlety that it has never been said, to my understanding, that for an employer to be liable for a case of asbestosis, they and they alone were responsible for the total dose that causes the asbestosis. And it follows from that liability would be sufficient if it could be shown that I, as the employer, had made a material contribution to the whole dose.
You would only have liability for the divisible part.
Yes, which is not really a material contribution at all. It's a but for. I accept.
Yeah.
I accept. But I'm trying to just deal with one concept at a time, if I may, to keep it intelligible to myself, if nobody else. If my lord will allow slightly more neutral language, my lord is aware, of course, of CARDA, again, authority involving Learned Friend and I, and that subsequently it was said that for the man that had asbestosis, the defendant that made a 2.3% contribution to the total dose was entitled to be compensated. It had to be required to give compensation to 2.3%. So it must follow that it is sufficient for somebody to have made a material contribution to the dose to allow them then to be sued in due course.
Just trying to be clear in my own mind. So you're saying what had to be foreseeable was a material contribution to asbestosis?
Yes. And that allows me then, I respectfully submit to say, that allows me to say it is perfectly reasonable to visit upon an employer a test of, if you are exposing somebody to visible dust, we know from the analysis of Mr. Mitchell that what you're doing is you're exposing them to a significant amount of dust, whatever significant means. It's not trivial. That the fraction that you can see is only part of the total cloud. There is the fraction you can't see. And if you can't measure it in any other way and you can't see it, how do you know it's there? So the visible dust becomes a harbinger, a messenger that there's something else going on. And it's the invisible dust that does the damage. And this also goes towards my lord's concerns about, well, what's the point of the spike? Well, actually, the point of the spike on my facts is that the spikes are what lead to the visible dust. And it's the visible dust that leads to the visual trigger. The visual trigger is what leads to the requirement to do something about it, whether it's to take advice, to read the documents, or to just reduce the dust. Very simply done. And that's, in sum, is the chain. My lord, the last thing to say is my own friend, Mr. Kent, gave you a series of figures for averages. And of course, you know what we say about averages in principle, but as figures, I have nothing to say in terms of Malone Friends mathematics, which appear to me to be, if I may
So
say.
when you say, Mr. Kent, you're not talking about the thing that Mr. Platt did that was handed in
No. This is, if you remember,
in his oral submissions.
yeah.
That's okay.
This morning.
They're dividing by 5
Exactly.
and 10.
Yes, I see. Yes, sorry, I'm with you now.
So the mathematics, I have no difficulty with. All I would say is that as a matter of fleshing out the point, it seems to me that there are 2 elements of dust that he missed out that you would have to add in if you were going to be looking at averages for any particular reason. And the first is that he, of course, the claimant claimed to do his own cutting as well. Unspecified time, only when he was showing somebody else how to do it. But more insidiously, he also complained of dust on his clothing. And that would have been a constant, albeit lower level sorts of exposure as well. And of course, wholly unknowable. Now, with your permission, I'm just going to turn my back. Yeah, the last line, to suggest that, of course, it will be obvious to this court that in any event, we say that the levels of exposure on the facts are sufficiently close to Jeremson that we come in to the Jeremson line of authorities. Those on the second help you further.
Anything else? Well, you won't be surprised to hear that we will be reserving our judgments. They will be circulated in draft in the usual way, in due course. No promises as to exactly when that is going to be, so that you can agree consequential orders, or if you can't agree them, produce short written submissions so that we can decide any dispute about the consequential order at the time of handing down. Also, of course, to draw our attention to any typographical or other small factual errors. You will all be deeply familiar from the Counsel General for Wales case of the limits for which the document, the drafts are being circulated, and therefore who they can be circulated to. Thank you all very much for carefully prepared and most cogently argued cases, and those thanks go obviously not only to those in the front row, but to those in at least 2 rows back. Thank you all very much.